Hi there, I am Reuben Kirkham at Monash University. In this talk, I'll present my paper on using European human rights jurisprudence for incorporating values into design. So, what is this talk really about? Probably the best starting point is value-sensitive design, which over the last decade or so has become a particularly important concern in HCI, with computers being increasingly present in the wider world. VSD aims to take into account human values in design, including ones which are human rights, such as freedom of expression and privacy. But VSD is not the only thing that attempts to do this. Human rights law does this too. The ECHR, or the European Convention on Human Rights, attempts to do a similar thing, but it also has the advantage of having the force of law, so in some circumstances, one might expect it could be more effective. At the same time, as VSD is becoming more human rights focused, lining up the two concerns may also have a positive influence on the law. My paper is a critical essay on this topic and looks at how we might be able to join these two concerns together. I'll start by looking a bit more closely at VSD, and I think it's worth saying it's not perfect. There have been some ongoing challenges, which I'll outline. The first is whose values we consider, with there being the difficulty of the researcher's values, or alternatively, universal values being inappropriately applied. The second shades into the first concern. What's a fair way of balancing people's values, especially where there are competing concerns that have to be traded off? At the same time, there are also practical concerns, including the lack of training to make value-sensitive decisions, and the fact that VSD is not normally put into practice in the real world outside of academia. The burden to do so is simply too great, in terms of workload and other concerns. Perhaps the overarching concern is legitimacy, which I identified as being the main concern in my paper. Why, after all, would self-appointed value experts be allowed to decide themselves as to what balance we should have on social issues? And at the same time, and not taking full account of the law, there's also a risk of values experts in effect arrogating decisions themselves, which have already been taken for an alternative and legitimate societal process. There's also a wider question of why policymakers should follow what value experts say. Is there really a good reason for them to do so? At the minute, it's a bit difficult to see a compelling case for it. As I mentioned in the introduction, human rights might be a solution to this problem with VSD. For this paper, I'll talk about the ECHR, i.e. the European Convention on Human Rights, and how we can make this fit. So, from the outset, the ECHR has a lot of advantages. As well as being the most recognised and effective human rights regime, it is set up as a living instrument that moves with the times. It has a whole infrastructure, including its own court, the European Court of Human Rights, and it is embedded in national legal systems for at least several hundred million people in Europe, with a lot of case law that's already balanced individual rights in a wide range of circumstances. And what's more, it has the force of being law, and along with that, an inherent legitimacy. In my paper, I have split the content of the ECHR into 4 different notional tiers, which I see as a way of making it more accessible and usable for people in HCI, either when taking value-sensitive decisions or researching the law more generally. I'll go through each of these tiers in turn. Tier 1 is the hard-edged or absolute values, like the right to life, found in Article 2, or the prohibition on slavery and forced labour found in Article 4. These can be said to be hard-edged because there are very few get-outs. For example, the right to life might be violated to protect others from being murdered or massacred, but only insofar as absolutely necessary. If it was possible to arrest someone instead, then the state should arrest them, rather than killing them. Tier 2 is probably the one that will crop up the most in HCI. These are qualified rights, where there is a balancing exercise, and engage issues like privacy and freedom of expression, including the appropriate balance between them. For the state to interfere with these rights, they have to do so only in accordance with the law, only to an extent necessary in a democratic society, and for a permitted reason. As you can see in the table on the right, the permitted reason varies across the different articles. Tier 3 is particularly interesting. I've elevated Article 9 into being its own tier because it's actually a mechanism for dealing with beliefs and values. It is incredibly flexible, with nearly any belief being accepted, with perhaps strange things like light worship being covered, even though that in and of itself is not a comprehensible belief to most people. Some more conventional matters that are covered include things like veganism, climate change, and even the British Broadcasting Corporation's values. However, the Article 9 protection implies, in practice, only to manifestations of beliefs, And the catch is that the person making an Article 9 claim needs to show an intimate connection between their belief and the manifestation of that belief. To give a couple of examples where a belief wasn't really being manifested, someone who did not believe in voting could, for example, instead choose to spoil their ballot. So a state requiring 100% voting turnout is not against the ECHR. And to give another example, someone who did not believe in funding the military could not avoid paying tax in general just because this is not connected enough with their belief in not funding the military. There's also a further limitation in that even if someone successfully gets through the hurdle of manifesting a belief, then the same issue that applies to other tier 2 values also applies, in that they're qualified. So there's another basis in which a state can lawfully restrict someone's practice of how they manifest their beliefs. Finally, there is tier 4, which is really important in that it provides a general non-discrimination provision, which also includes an expanding set of other statuses that are protected. For example, disability was not in the original Convention of 1950, but has become protected over time. So that's my short tour of the European Convention on Human Rights. The other key thing that I do in this paper is make proposals. After all, this is a critical essay. I made 5 proposals in the end, and they reflect different ways that people might engage with the ECHR when considering values in design. These also vary in the degree to which they implement the ECHR approach, and for the most part they are complementary to one another, so you can adopt some but not others. The first and simplest approach is just to use the ECHR as a sort of library. In effect, just like with value-sensitive studies that have already been completed, one can reuse to a greater or lesser extent that other work to further inform VSD-type exercises. In this case, the ECHR case law would just serve as a further set of examples, expanding what is available, saving time and helping to have more legitimate decisions. The second approach that I propose is to apply the ECHR and the tiers I set out as, in effect, a value tensioning process. This has the advantage of legitimacy and also helps solve the what values problem, because the balance between values is already predefined and structured. A third proposition that I add is to expressly test for non-discrimination. Currently there isn't an express test set out in VSD, and adopting one would avoid accidental discrimination. Mimicking this part of the ECHR would perhaps overcome what is arguably a striking flaw in how VSD is currently followed and implemented. Approach 4 is being right-sensitive rather than value-sensitive. In other words, we shift our thinking and follow a more legal approach. This would be more a substitution of VSD with the ECHR. This goes quite a bit further than the other proposed approaches. As we would be doing law in effect, what would result would dovetail more with the practical expectations of public authorities and organisations, making the resulting system more likely to be operable in the real world. The fifth and final approach is more a linguistic one. If a value has already been recognised as being such under the ECHR, then we're best off putting our arguments and reasoning in those terms. This may down the line have the real advantage of helping develop the law, and thus making it more centred to the concern of HCI practitioners. This means we would go beyond the reactive approach of responding to law, and instead actually contributing towards it. Of course, my paper is a critical essay, so I don't claim to have all the answers, and putting this into practice might not be 100% straightforward. What's more, if we're going to do human rights, then we need to make sure this is genuine and not just a nod. It's also worth noting at the same time that human rights is a minimum, even if it is quite an insistent standard. So we have to be careful we don't just meet the minimum standard of human rights, not least because there are causes and values that matter outside the ECHR and other human rights systems. Just to give a quick example, the widening gap between rich and poor matters, but there's no human right to be well off. So the ECHR is an important concern that we should integrate, not in an uncritical fashion. Thank you very much.